Um, welcome everyone. I'm glad you're here to join us on our webinar today. I am pleased to present Rebecca from Curtis Thatcher, who will be doing our presentation today. And a big thank you. As you know, we've got a new sign up here for 2019 to 2020 Main Summer Camp webinar series, thanks to Andrew Skog and Ben. So with that, I'm going to give you Rebecca.
Right, thank you, Bijette. So as Bijette said, I'm going to be presenting today on some employment law topics that have come up and that affect camps and that you have all asked for some presentations on. We start the presentation. As Ron's pulling that up, I'll just say we're going to cover 4 big topics today. And as I was putting this together, I realized just how big these 4 topics are. So it might feel a little rushed because these are big topics, but I'm happy to come back and go through anything that doesn't come across the first time around. So these are the employment law basics that apply to Maine summer camps that you've been asking about. Are we okay, Ron?
Somebody just said it stopped working.
Looks good now.
Okay.
Okay. All right, assuming this is working. This is a sample of the laws that apply to the employment field. As you can see, it's a real alphabet soup of many different laws. And we obviously don't have time to cover them all in 1 hour today. So I'm going to hit on the highlights for you here. I'm going to call this sort of the speed dating version of employment law, where we cover a topic and then move on. And we can try to pick up some questions at the end if we have time. So the top 4 I heard about were hiring and firing practices, employment discrimination, drafting employment policies, and I think this is going to fall off of my chalkboard here, wage and hour compliance. These are the 4 big topics, and hopefully in 15 minutes or less per topic, we can get through them. And Bijette, feel free to stop me as we go through if something's not clear. I'd love it. Without Jack here, I need somebody else to talk to. Right. So first up is hiring and firing. And I've started this even before you're at the hiring stage, when you're coming up with your job descriptions for the folks that you will be hiring. And the first thing you're going to want to do, which I'm sure everyone does already, is identify the camp's needs as the employer. It's important to figure out what you need before you post a position. And the reason you want to do that is then you want to make sure that your job posting, after you've figured out what you need and drafted what that need is make sure that your job posting does not contain discriminatory language, either directly discriminatory or indirectly. And what do I mean by indirectly discriminatory? The EEOC, which is the federal agency that's charged with pursuing discrimination claims and making sure that employers are not discriminating, has identified certain types of words that are problematic in job advertisements because they suggest age discrimination, gender discrimination, other sorts of discrimination. So one thing you want to be careful of when you're putting together your job description is to avoid certain, what the EEOC calls trigger phrases, asking for young and energetic folks, or 0 to 1 years of experience, a few good men. I can't imagine any of you advertising that way, but just in case. Cleaning lady, Christian landscaper. All of these things, I think you can see pretty clearly, could implicate age discrimination or gender discrimination, discrimination based on religion. I will stop and say that there are a few times where you can make distinctions, and I'll get into that a little bit more later. But for instance, Christian, you can sometimes, if you are, say, a religious camp that is based on a religion, you can sometimes prefer members of your own religion in certain circumstances. Those circumstances probably would not cover asking for a Christian landscaper, because there's no reason your landscaper needs to be Christian. It's not like you would be teaching any of the children the Christian tenets as a landscaper, but that's something that you would want to check on, even if you were trying to make a distinction on that. And there are sometimes distinctions for what we lawyers call bona fide occupational qualifications, which can sometimes come into play if you are preferring one sex over another, say if you're in a same-sex camp situation. But again, it's going to be a very limited world where you can do that, and I'll get into that a little bit later. So just be careful of those trigger phrases, and I think especially when you're talking about job descriptions, because the point of a job description is to display it to the world. So everyone is seeing your job description, not just the people within your camp at that point. So you run the risk of somebody who might not even want to be working at your camp, but seeing the description and saying, haha, I've got a discrimination claim against them. So just remember that this is a very public document, so you want to put your best foot forward here. And then you want to clearly and accurately define the essential requirements and functions of the position. Why is that important? It's because it will later have legal significance if an employee makes a claim for unlawful discrimination. It provides an objective standard for you to measure the prospective employee's qualifications against down the road, to make sure that if you do end up terminating them, it's because they were not able to perform the job functions and not for any discriminatory reason. It matters often in a disability context. If you end up having to terminate somebody with a disability, it's because they were not able to do the job function, not because they had a disability. So that's one thing to think about. And because it is so important, I recommend that you keep a copy of the job description even after you've hired for the position. Keep it in the employee's permanent file, and then you always have it to refer back to make sure that the employee is doing what they're supposed to. So in addition to those, and we have the video here?
Right.
Sorry.
Screen.
Might have technical difficulties again. What I'm hoping to display to you is just a quick checklist of some other things to put in your job description. Here we go. Okay. So, you know, some of the things you probably obviously already put in your job description, but it's a good idea to try to hit all of these if you can. The job title, obviously, whether under the Fair Labor Standards Act, it would be an exempt or a non-exempt position, because that will help inform the employee whether they can expect to get overtime or not. Supervisory relationship, if any, and by that I mean you might want to say who the employee would be reporting to, who the employee supervisor, you know, maybe they just report to the camp director, or maybe they report to the head of maintenance or somebody else. And also if any other employees would be reporting to this employee, so that they understand sort of the chain of command. Location and travel requirements. That obviously is a big thing with camps, letting them know where this job is located. You're probably not going to be in downtown Portland and able to access, you know, public transportation and things like that. And there might be some travel requirements if you need to go on hiking trips and other sorts of things, if that's going to be a problem. Better to put it up front. The purpose and objective of the job, which can just be as simple as saying, to provide janitorial support to the facilities manager, or serve as director of the waterfront activities. The essential functions of the job, we just spoke about why that's important. Just identify the key responsibilities of the position. I realize with a camp that's running 24 hours a day sometimes, those responsibilities, you couldn't possibly list all those responsibilities in one just description. So try to hit the most important ones, put them in order of importance, and then discuss the remainder when you can. The physical demands of the job, again, with camps, that's especially important, because we're not just talking about the ability to lift light weight in an office setting necessarily. You might have some extra physical demands. You might need to be able to take kids up Katahdin at some point.
Right.
So identifying those physical demands early, heavy lifting, walking, kneeling, uneven terrain, climbing, standing, and hearing and eyesight. Those things are important. You want a lifeguard who will be able to see the kids out in the water. Experience, if that's skills, if any special technical skills are required for the position. Experience and special working conditions, and again, that's something that camps have to be especially cognizant of, that you do have special working conditions. Often it might be a live-in position versus you're not going to be home for dinner every night. So don't think you're going to be living here at camp. It might include travel, that kind of thing, long hours. So those are all the things that an ideal job description would have in it. Which gets you to when you actually have applicants coming in for the job. How do you interview them, whether it's in person or via video conference or phone? I thought it might be a good idea to sort of run through some of things that you can and cannot ask with respect to certain categories of information. So first up is age. Questions that are okay, you can confirm that the person is over the age of 18 if that's something required. You can ask for dates of education and employment if you're using it for verification of information already given. What you cannot ask is how old are you, what's your date of birth, what are the ages of your children. Any questions that tend to identify applicants over the age of 40, that's the magic number for age discrimination claims. That's the magic number in the federal world. In Maine, you actually can't discriminate against someone on age, whatever the age is. So if for some reason you were, preferring somebody who was 40 and discriminating against people who are 25, that would also be illegal under Maine law. So any questions asked for the purpose of determining age, even if they seem innocuous, like the year they graduated high school, those are all questions to steer away from.
Are you able to put it in like an optional section? So there's not a requirement for them to fill it out, but.
That's a good question. I suppose you could. I mean, theoretically, I think for the most part, people usually are pretty able to tell just based on the resume or an application how old the person is within a few years anyway. So unless it matters for the job, I wouldn't do it. Same thing with driver's license. I know some people ask for driver's licenses outright. The only time you should really be doing that is if driving is an essential function of the job. So, if you are going to be required to be driving the van to take trips, then yes, you can say. And even in that point, you don't ask for their driver's license at the outset. You ask, do you have a valid driver's license?
In many cases, a driver has to be 21.
Yes.
So that can be asked?
Yeah. Yes,
Okay.
if they have to be, and then you have a legitimate business interest for it,
Okay.
right? It's not for discriminatory reasons. Then you have a
Right.
defense for why you're asking.
Thank you for that.
Next, I've sort of smushed a bunch of things together, but they all kind of fall in the same category of things, which is it's illegal to discriminate against someone based on national origin. And so a lot of these questions go towards the national origin idea. So it is okay to ask somebody, and especially with camps where you do sometimes have people coming from overseas to work, it is okay to ask, are you authorized to work in the United States? You have a right to do that, and you also have to ask for the proper verification in documents afterwards, but that comes after hiring. At this stage, you would just take their word for it and say, are you authorized to work? What you do not ask is, are you a US citizen, or when did you acquire citizenship? Are your family citizens? Any of that, their citizenship should not matter to the hiring process. Mm-hmm. You can ask, in what other cities, states, and countries have you lived? But you can't say, where were you born? Because that does not matter. The birthplace of the applicant or even the applicant's family is not proper because, again, goes towards, are you trying to figure out what their national origin is? And it just raises red flags that you don't need to raise. With languages, it's okay to ask what, if the applicant can speak or write in English, if that's part of the job function. I imagine in most camps it is necessary to be able to at least be able to speak enough English to perform the job. So you can do that, but you cannot ask what is your native tongue, or how did you learn to speak X language, or anything like that, because again, that goes to national origin.
We have another clarification about a driver's license.
Can we read the question?
The question is, for clarification, we can't ask if someone has a driver's license on the application, but we can in an employment paperwork after they're hired.
So you can ask if they have a valid driver's license in the application, if they are going to be somebody who you're considering to be a driver, but you don't want to ask them to submit their driver's license
Right.
at that stage. You ask for a copy of the driver's license afterwards when you're doing the verification. And the second question you already covered,
Yep.
right, Ron? Okay.
Right.
Here's another bunch of categories I smushed together, which are parenthood, child care, and marital status. This is easy. There is no okay parenthood question that you ask. So don't ask, even if the person looks like they're about to give birth to an elephant tomorrow, are you pregnant? Do you plan to have children? Any of that, none of your business. And you cannot ask that, because the problem with asking that is then if you don't hire them, what's that person going to say? They did not hire me because I was pregnant. I'm going to be going out on maternity leave, whatever it is. You can't discriminate on that basis, so don't ask the question. As far as child care, you can ask, is there any reason why you cannot work nights or weekends, or any reason you could not live at camp all summer? Is there any reason you can't perform overtime if needed, if that's something that's required for the job? What you can't ask is, who's going to look after your kids if I need you to come in at 6 a.m. every day, or who cares for your kids, or what happens if one of your kids is sick, or how old are your kids? Any of that, again, not really any of your business, and don't ask, because it just looks like you're looking for a reason to discriminate. You also cannot ask, are you married? Marital status is protected under Maine law, so you can't say, are you married, or do you prefer Miss or Mrs. or Ms.? I would just go with Ms. for everything in that case. Don't ask if they're single, don't ask if they're divorced. Marital status, again, is not part of the job interview process. What you can ask, and I think this probably happens with camps given what close communities you are, is, do you have a close relative who works at camp? And if so, who are they and what's your relationship to them? That would be okay to ask. So even if it is somebody who, my spouse works at whatever, at that point, it's okay. We've just asked what their relationship is. And then another broad category that I've had to put together just for time, religion, disability, or other physical condition. Again, the question, is there any reason why you cannot work overtime or weekends? That's okay. What you can't say is, does your religion prevent you from working weekends? If what religious holidays do you observe? Any inquiries into religious affiliations? Again, with the caveat that if you are a religious organization yourself, then that would be a different story. You cannot ask, and I also have, again, do you have a close relative who works at camp? As far as disability, you cannot ask, do you have a disability? Are you handicapped? Do you think a handicapped person could do this job? The only thing you are allowed to do under the ADA is an inquiry into the ability to perform job-related functions. So you can ask the applicants to describe, you can check with the applicants to see if they think they can do the job functions, and then you can ask them to describe how they would be able to perform the job functions. And that's pretty much all you can do under the ADA. You cannot ask for pre-employment medical examinations, except for certain conditional post-job offer medical things. So, like if you require vaccinations, it's okay to ask for that afterwards to make sure that they've had it, but it can't be a precondition to employment. So that's a quick and dirty, the do's and don'ts of interview questioning. There's a lot of other categories that you should be careful of. You know, things that you have to be mindful of that probably don't happen that much in the camp context, but I'll just run through them. Military status is something else that's protected. Criminal records, union membership. I don't know if there's any counselor unions out there, but in case they spring up, that's something you cannot ask about. Credit rating, a lot of these things that I don't imagine you're probably asking anyway, but those are the big buckets. Another point before I move on is reference checks. If there's a question that you should not ask an applicant, you also should not ask that person's reference the same question or a question to get at that same information. So what you can ask with reference checks, you know, don't ask about former employees' age or national origin or marital status, disability, any of that. But what you can ask about are job titles and duties at former jobs, work performance, reason for leaving, would they rehire that person? Is there anything else in that person's background that would affect their suitability for the job? Honesty, reliability, whether engaged in improper conduct. You can ask all of those type things of the references. I will say, as an employment lawyer, I often advise employers who get called for references to not give all that information out, because sometimes that opens them up to weedy situations. Mm-hmm. So oftentimes, even if you ask those questions, all former employers will give you is sort of the dates of employment and a verification that they worked for, and maybe the general duties. So don't be surprised if you don't get as much as you want from a reference. It's just because lawyers have been at them and they're keeping close-lipped. And another thing that has come up more recently, by recently I mean 20 years, but is internet searches. You know, when you Google an applicant before they start a position or when you're considering them, it's still okay, technically okay under Maine law to Google somebody that you're considering for a position before hiring, so long as there's two things to be mindful of. First, you cannot require them to give you access to their sites. So, you know, say you're Googling somebody and it's password protected, or you have to be a friend or whatever to see their information. You can't make a condition be like, okay, well now I'm gonna go into all of your social media, so I need you to give me access to it. Please friend me as your potential employer so that I can look at everything you've ever posted. You can't make them do that. The other thing to be careful of is what you see, you can't unsee, and it becomes problematic if you see things on the internet that might lead somebody to believe that a picture you saw or a post you saw might have led you to improperly weed out that candidate. You know, whether, and I actually seen this not in Maine, but in other states, there was a employment discrimination case where it was a gay counselor, I believe, who was fired from, and I think she worked in a religious camp, or maybe it was a religious school, but it was some religious-based organization. She was a teacher, she was a counselor, she was gay. She had not come out as gay within her workplace, but her employer went on her social media, saw pictures of her with her girlfriends, and then later fired her. And so she was able to say, well, the reason you fired me is because you saw these pictures of me. So you want to be careful, because what you see might lead somebody down the road to say, I was fired for this reason, which is discriminatory. So that's my caveat there. It's hard because I think everybody's first instinct is to Google somebody, and you can learn about them, but you just have to be very mindful that what you learn there does not lead you to make a decision that could later be seen as discriminatory, as not hiring them for a protected reason. Even if that wasn't the reason, but just if there's some specter of it. Okay, so that was hiring. Now let's get ready to fire people. So Maine is what we call an at-will state, which means that you don't need to tell and first of all, when you say at will, like that's just the status quo. You don't need to tell your employees that they are at will. The default is you're at will, which, yeah.
Because I always felt I had to put it into the offer agreement. And
well, that's a very smart thing to do, Brigitte. I'm glad you said that. So in most cases, you are dealing with at-will employees, again, unless there's a collective bargaining agreement with your counselor's union that doesn't exist, or if there's some other contract. So it might be that your camp director or one of your higher-up employees does have a contract that specifically carves out that it's not an at-will. So it's not to say that at-will is always the case, but that is the default. Even if you tell a counselor that they're hired for the summer, which, you know, in the counselor's mind might mean job security for the summer months, that promise can be canceled out if you clearly state in writing, as Brigitte just said, that employees are hired on an at-will basis, or that their contract says they're on an at-will basis. And I think it's a good idea, especially when you have counselors and other employees who might be coming from other states and other countries who would not know that Maine is an at-will state. Better for you as the employer to spell it out. And in addition to putting it in the contract, this can also be done in the employee handbook, just as a blanket statement. So why does it matter that we are an at-will state? That means that under Maine law, an at-will employee may be terminated for any reason that is not specifically prohibited by law, which brings you to the question, what is specifically prohibited by law? And that's discriminatory reasons, retaliation for filing a claim or asserting rights, or refusing to do an illegal act. You know, if the employer says, you know, we know we're supposed to have these safety harnesses, but they cost money, so, you know, we're not going to use them, and don't tell anybody that we're using them, and I want you to throw kids up in the tree without harnesses. You know, if you refuse to do that, that would be a protected reason. Despite the fact that we are an at-will state, depending on the circumstances of the termination, you might want to consider a separation agreement. Again, this wouldn't necessarily be with every employee who crosses your doors. But if there is any chance of a discrimination claim or other sort of claim being made later against you, if you have a disgruntled employee, it might be worth the peace of mind to the camp to pay sometimes a little bit of severance. You know, here's 2 weeks pay, even though we're letting you go early. And in exchange for that additional severance pay, then they would agree to sign a release, which releases the camp of all future discrimination claims or any other claims that they might have against the camp. Even if the camp didn't do anything wrong, the employee could still bring a claim if they're unhappy, and that can be costly to defend against. So, you know, even if you're right, and even if you get it dismissed as early as possible, it is still energy and cost that you're expending there that you might want to be spending elsewhere. So that's why I sometimes suggest that if there's any kind of doubt in your mind that this employee might come back and try to do something, better to take that off the table when they leave. The other thing to think about when you are terminating an employee, this is a new law change just this year, it went into effect in September, is that Maine pretty much, except for very, very limited circumstances that I can't imagine applying to camps, does not allow non-compete agreements anymore. So you can't ask an employee to sign you can't say we're hiring you and after you leave here, you can't go work for another camp for X number of months or years. That's pretty much not allowed anymore. So don't ask employees to sign a non-compete agreement, or if you do have a legitimate basis for having a non-compete agreement, I would suggest you speak to an attorney first just to make sure that it falls within those limited circumstances where it's permitted. And now I want to back up. So we did hiring and firing, and I just kind of want to talk a little bit about before you get to the firing stage, because even though you have the right under Maine law to terminate an employee at any time, without warning, without any intermediate measures, You might want to also employ some escalating disciplinary steps, and I imagine most of you do. That's not to say that there aren't some cases where the behavior was so egregious that immediate dismissal is the proper channel to take, especially when you work in a place where safety is such a concern. But often camps and other employees will want to take these extra one or more of these disciplinary steps. You might start with verbal and or written counseling, issuing a performance plan, which would be in writing about how to, correct behavior. Suspension, although with this you would want to be careful if you're suspending without pay. There are some FLISA things that you want to be mindful of. And then finally termination, so that and you don't have to go through all of the steps. You can, just go from written to whatever. But whatever you are going to do, you want to make sure that it's all in writing. You want to document everything. And I suggest that when you can, you also have the employee that's being disciplined sign the documents and keep them in their file. Because, if you're giving somebody a written warning, you're going to want to sit down and go over it with them, make sure they understand, and then have them sign at the end. You'll have employees who might say, well, I disagree with what you're saying. I didn't do anything wrong, so therefore I'm not going to sign that. Let them know that they're not signing that they agree to everything you say, but they're signing that you've spoken about it and that they understand that this is the process that you're employing. That's all their signature means. And then the reason you want to have everything in the personnel file and documented is that under Maine law, if the employee requests it in writing, the employer has to, within 15 days of receipt of the request, provide written reasons for the employee's termination. So you kind of want to make sure, I say that you have your ducks in a row here, so that you've got everything documented, so that if the employee later does ask for those written reasons, you have them well laid out. And you want to be as succinct and accurate as possible. For example, your employment was terminated for, and then just list the reason, poor performance, failure to comply with camp policies, whatever it is. You want to put that in there. Again, this is sort of an insurance policy against a later discrimination claim, to be able to say, no, they weren't terminated for a discriminatory reason, they were terminated for these reasons. And also, before I leave this, Maine law also gives employees the right to request a review of their entire personnel file. So you want to be mindful of what goes in the personnel file, because at any time an employee can make a written request to see their employee file. That can be a current employee, it can also be a former employee. Again, the employer has to provide it, this time within 10 days of receiving the written request. And the employee has the right to both see it and also have a copy of it, make a copy of it. And failure to do either the written reasons for termination or failure to supply the personnel file will give you a fine of not less than $50 and not more than $500. So something to be careful of as you're.
Before you leave, we do have a question, which is, how specific does your job description need to be? Is a general activity counselor job description okay versus a specific job description for a sailing counselor?
So that's a good question, and it will sort of depend. I mean, if I think sometimes probably you are just looking for general counselors, and then you're going to sort them into specific jobs based on who's best suited for what after the fact, but you've got the good people and now you'll distribute them as best you see fit. But if you are specifically looking for a sailing counselor, then I would recommend that you put that out there in your job description, because what you don't want is you don't want to have, for instance, let's say someone apply who is legally blind and maybe would not be the best choice for a sailing instructor who needs to be able to see the kids under their charge in the boat. You want to say that up front, so that when the person who is legally blind does not get the job as sailing counselor, there's a good legitimate reason for it that was non-discriminatory, versus if they just applied for a counselor and in the back of your mind you were picturing a sailing counselor and they applied for a job as a counselor and there's no reason that they cannot be a general activity counselor, but there might be a reason why they cannot be a sailing counselor, if that makes sense, Karen.
Yeah.
Okay. So all of the things that I'm talking about, you might have heard the same word over and over again. Pretty much everything is to protect you in the employment context against claims of discrimination down the road. So next group of slides are going to be about employment discrimination, and these get a little wordy, and I apologize in advance, but it's just a massive topic, and I can't fully do it justice here, but I'll do the best I can. Discrimination in the workplace, it basically just occurs when an employee or an applicant is treated differently than others. Both state and federal anti-discrimination laws protect workers. The reason we have these laws is to protect those who have traditionally been excluded from employment opportunities. Those include Title VII of the Civil Rights Act, the ADA, the Americans with Disabilities Act, the ADEA, which is the Age Discrimination in Employment Act, and then the Maine Human Rights Act. And the Maine Human Rights Act, I will say, in some ways mirrors these other laws, the federal laws, but it is also more restrictive than a lot of them. In the federal context, some things are still not expressly protected, and I'll go into that a little bit, and under Maine law they are. And you always, when you are an employer, need to follow the more protective law, the more strict law for the employer. So I'm going to be giving you the stricter versions to make sure that we're all on the same page. So there are three types of prohibited conduct under these anti-discrimination laws. First, you have the overt discrimination, like I didn't hire that person because they were Black. That would be a case of overt discrimination, and disparate impact, which sometimes piggybacks onto that. Harassment, which includes sexual harassment, but is not limited to sexual harassment. And then retaliation, which often follows discrimination claims. So it's generally unlawful to refuse to hire, to fire, or to treat differently in compensation or work conditions based upon a protected classification. And those protective classifications include, these are the big ones: race, color, national origin, sex, gender, sexual orientation, disability, age, religion. There's a few others, but these are the ones that you see most often. Not everything is a legally protected class. So some forms of discrimination, even though it sounds like they shouldn't be, are okay. You can discriminate against people with face tattoos if there's a reason you don't want to have face tattoos in your camp, because people with face tattoos are not a protected class under any of these discrimination laws. That said, if there is a religious or a cultural reason that this person has a face tattoo, then you might want to tread a little more carefully, because then you might be a national origin land. But that's something to think about. And then when you can, I said you can discriminate, and so these are some of the times that you are allowed to engage in some different treatment. It's very narrow. You have to have the bona fide occupational qualification defense, and I'm already going to expect a lot of questions on this, and it's a very thorny issue. So what that means is, the other way you can do it is if you show that the person that you are discriminating against would be unable to perform the normal duties of the job. So, my sailing instructor example might be that kind of case where even though they are protected under the ADA, because they would not be able to perform that job, or let's say, you are hiring an archery instructor, you maybe do not want the legally blind person teaching the archery lessons. That might be a way where then you have a defense, even though you are discriminating because of their disability, it's because you have a bona fide occupational reason for it. What you can't do with and we sometimes refer to bona fide occupational qualifications as BFOQs, not that that's that much easier to say, but you can't use stereotypes as your defense. You can't use something like, well, we only hire female counselors because female counselors are more nurturing. That's using a stereotype, and you're not allowed to do that. That's never going to be upheld. You also, I have never seen, and I cannot imagine any circumstance where a race qualification would come into play and be upheld. There's never any reason to say, well, you know, we only use people of South Asian descent because of XYZ. That's never going to be upheld. And so the only thing that you see here usually is some sex discrimination, and even then it is very, very narrowly construed. So some examples where you are allowed to discriminate on the basis of sex: if you are advertising for a sperm donor, a wet nurse, clothing models, things like that. You know, if you're trying to show things that almost biologically can only be done by one sex over the other, that would work. Those things do not happen in camp usually. I don't imagine anybody's looking for those occupations. So I know probably everybody is saying, well, what about cabin counselors? You know, isn't there a defense there? I don't think parents are going to like, you know, our male counselor bunking with the group of 7-year-old girls. And yes, so you can't use some things, but the way the law, let me back up. So there's no, I can't give you a get out of jail free card here, but I can say that yes, probably that would be okay if you have a legitimate reason for it and you've kept it as narrow as possible. The way laws develop is first Congress or the legislature passes a statute, a law, and then it's up to the courts to apply that law to the specific factual scenarios on the ground. And then once a court decides something, then we can say that is also part of the law. Unfortunately, we don't have very many cases where courts have tried to figure this out in the context of camp counselors or residential schools. But there are a few, and the ones that have been decided have often said that yes, there is a legitimate, a bona fide occupational qualification to having a same-sex counselor bunking with kids, or sometimes even outside of the cabin context. You know, in terms of role models, it's been held to be okay if you want to give your campers a role model of the same sex to look up to. It's especially, I think your best hook here is the privacy and safety concerns. Courts have been very sympathetic to the idea of, you know, you don't want to subject the 7-year-old girls to changing in front of an adult male in the cabin. That has been very much upheld to be a qualification that passes muster for making that sort of discrimination. But I guess my warning here would be whenever you are making a line, drawing a line to make a discriminatory choice, just stop and ask yourself why you are drawing that line, why you are preferring one sex over the other, or whatever the preference is, and is it necessary? And is there a less discriminatory way to achieve the same results? So I think a blanket policy of saying, even if you run an all-girls camp, saying we only hire female staff, period, from, you know, the groundskeeper all the way up, that probably would never pass muster, because really, is there any reason that you need to have a female groundskeeper? There's no privacy or security concerns. You know, they're not serving in a role model capacity. So just be mindful of that, and it all comes down to a very fact-specific inquiry given your situation. So there's not going to be a hard and fast right and wrong answer. So think carefully. And I would also say, be mindful of your own implicit bias when it comes to discrimination, both in the hiring context and as you make any sort of choices after somebody's been hired about who gets assigned to what. I find the implicit bias such an interesting topic and worthy of its own. You probably have courses designed already for it, Bichette, because there's not really time to cover it now. But if anyone hasn't, I would recommend going Harvard has online an implicit bias test that you can take to figure out your own implicit biases, which is very interesting and leads to some really good discussions. So something to be mindful of. Okay, so that's the overt discrimination, and now moving on to the hostile work environment. And that equates to unwelcome, unwanted, or offensive conduct based on or because of an employee's protected class. Again, protected class is race, color, national origin, sex, sexual orientation. And that sexual orientation, I'll stop and say, that's one that the federal law does not explicitly call out sexual orientation. Federal courts for the longest time have been interpreting sex to also include sexual orientation, so that they have not allowed you to discriminate against someone because they are gay or because they are straight or whatever. Under the new administration, that's been sort of changing the way they're interpreting some things. But all of that really doesn't matter to us here in Maine, because in Maine, the Maine Human Rights Act expressly protects sexual orientation as a status. So that's there. So when you're talking about hostile work environment, you're looking sort of at the general atmosphere of the workplace, and includes verbal and physical conduct that unreasonably interferes with an individual's work or performance, or creates an intimidating, hostile, or offensive working environment. The big one for hostile work environment is sexual harassment. That's where you often see hostile work environment cases. Jack and I did a sexual harassment webinar. It took up a full hour on its own, so I'm not going to be able to cover it. So I'm mostly going to ignore it here and just touch on it a little bit and refer everybody. Ron's put that webinar up on the Maine Summer Camp's website, so that's available there for more on sexual harassment. I'm going to talk about the sort of hostile work environment that is not sexual harassment or gender-based necessarily, because it is possible to have a hostile work environment based upon race, age, disability, religion, any of those other protected classes. So that might be an employee that repeatedly is subjected to derogatory comments or stereotypes related to their race or religion, or an employee tries to get a coworker to quit or just be miserable by spreading untrue and malicious gossip about the coworker because of their sexual orientation. I'm sure you can imagine all kinds of awful things that human beings do to one another. So what can you do as a camp to stop that? I think the first thing, we talked about this in the sexual harassment context too, is defining respectful and appropriate behavior. That should start way before any incident of discrimination or harassment occurs. This is your opportunity to create a culture of respectful behavior and to set a standard for what everyone should be following. So you want to set a behavior standard that everyone knows about, everyone agrees with, and everyone is committed to follow. Even if by committing to follow, it's that they've accepted employment with you, they're agreeing to follow the standard that you've set. And having that easy to understand standard makes it easier for coworkers to recognize when somebody's crossed the line, and it gives them some empowerment to speak up about it. And you should make sure that your supervisors are setting a good example of that behavior. And when I'm sometimes going to talk about supervisors here, and I'm sometimes referring to camp. And when we talk about camp as a person, there is no person that is camp. So under the law, what counts as camp is what the supervisors are doing, what your management is doing. So everything that your supervisors are doing is what camp is doing. So you want to make sure that they are in line and understand the behaviors that you are trying to model, and make sure that they understand the procedures for dealing with discrimination, which I will get into. So camp also needs to make sure and make clear to its employees that they should feel safe reporting incidents of discrimination or harassment. And you might say, well, why in the world wouldn't somebody want to report discrimination or harassment if it's making them miserable? There are lots of reasons employees don't report these types of things. Fear of losing their job, fear of retaliation, fear of getting someone in trouble, fear of just disrupting the workplace, fear, especially when you're dealing with people who are used to trying to get along with everyone else. Fear of being accused of having no sense of humor when people are making inappropriate jokes that are based on race or religion or something else. You know, that fear of being a wet blanket who's saying, I don't think that's funny. That's one thing that plays in. Fear of being embarrassed by by reporting. Fear when it comes to some of the sex and sexual discrimination. Fear of feeling like less of a man or less of a woman for speaking out about it. Fear of not being believed. And the fear of not being believed, you know, it's discrimination and harassment is a hard subject because it usually is subtle and inconspicuous. It's not the overt, I am teasing you because you are Black. It's much more insidious than that. And so I think it takes sometimes employees a while to understand that it is even happening to them. And then you have the fear of, okay, I think I've internalized it, but will somebody else believe me when it is so subtle? So those are all things that might prevent people from reporting. So what can you do to help people make those reports and prevent the discrimination? You, as the camp, should define for employees the process that camp follows for reporting discrimination claims. Have a clear mechanism for reporting, including the ability to report to another member of management if the supervisor is one of the people doing the harassing. You should give the opportunity for a complaint to be made verbally or in writing. Once you learn of an incident, and when I say you, I mean the supervisors, you have to take immediate steps to stop the inappropriate behavior or conduct as it occurs or as soon as it's reported to you. You also have a duty under the law to investigate as promptly as possible and also to be as discreet and confidential as possible, understanding that not everything can be fully confidential in order to do a full investigation. And then you want to be careful to guard against retaliation, because now that the person has made the complaint, the next step, and I said this in the sexual harassment context too, but often what you see succeeding in court, even when the initial discrimination complaint fails, is that the employer then retaliated in some way against them or allowed the coworker to retaliate against them by treating them differently because they made this report. So be mindful of that and be on the watch for it. And then because your supervisors are camp for legal purposes, you have to make sure that they're properly trained to handle these reports of discrimination and harassment and know what to do when they come in. This is another subject where there are posters available from the Maine state website, and I think I've got a link posted later in the presentation. Maine does a really nice job of putting all of the required posters, both federal and state, in one place for you to download and put up in your workplace. So this is another thing that you want your employees to know, that they have the rights to do these things. They also have the right to go to the Maine Human Rights Commission. More responsibilities. Just remember that all employees are entitled to work in a workplace that's free from harassment and discrimination. And I say that because discrimination and harassment can come not just from coworkers, but from anyone who comes into camp. Delivery or service persons, imagine maybe some of your kitchen staff is being subjected to derogatory comments or jokes from one of the delivery people who comes weekly. They have a right to be free from that. That's affecting their workplace, even though you don't have control over that delivery person. You do. You can call their employer and say this needs to stop. Or you can make sure that the kitchen person is not there. You can do all kinds of things. Also parents, other visitors to camp, and sometimes even campers can make comments and things that are not appropriate that make your employees feel uncomfortable or discriminatory, and that campers are under your control, and so you have an obligation to stop that, whatever corner the discrimination is coming from, the harassment is coming from, it's up to the camp to put a stop to it. It's the camp's responsibility to make the workplace safe. And if you don't, the camp can be liable. They can be liable for the discrimination or harassment that your employees experienced. Also for the failure of the camp supervisors to fulfill those obligations I talked about to prevent, report, and investigate the incidents. And they can be liable for retaliation against the employees. And when I say liable, what I mean is that they can face a complaint from the Maine Human Rights Commission, which will investigate you. They can also face court cases if the employee decides to sue you. And you can end up paying hundreds of thousands of dollars, both in damages, and you can also be obligated to pay not just your attorney's fees, but also the other side's attorney's fees if they're successful. And that's to say nothing of the reputational damage that that does to your camp, and also just the morale. You know, the other reason, aside from all the scare stories about ending up in court and losing your camp because you had to pay hundreds of thousands of dollars, preventing discrimination is also just the right thing to do. And I think it's up to all of us to work hard to do that. Before I leave discrimination, this doesn't really fall under employment only, although it does. But discrimination under the ADA is something I think we see a lot of in camp, both in specifically in it. So discrimination based on an individual's disability is prohibited, and it applies both to employees and to camps, and to a limited extent to visitors to your camp. And the ADA requires both employers and entities that provide services, and camps are entities that provide services. You have a responsibility to provide reasonable accommodations to covered individuals, to individuals with disabilities, to allow them to fully participate in your services. So we see this, Jack and I see this a lot in the camper context sometimes, when you have a camper coming to camp maybe with epilepsy or diabetes or something that's going to require some extra care at camp. And it's up to the camp to figure out how to put in reasonable accommodations so that that camper can take as full advantage of the camp program as every other camper there. So that's what the reasonable accommodations means. A reasonable accommodation is one that does not fundamentally alter the nature of the program or services provided by the camp, or which does not otherwise cause an undue burden on the program. What constitutes an undue burden depends on a number of factors. I think the important, and again, this is a really big topic, so putting it on one slide is ambitious, but I just want to put it on your radar and say that what the ADA requires in these types of things, whether it's employee or camper, is that the camp engage in this individualized interactive dialogue with the individual, or in the case of campers, with the individual's parents, to determine how, first, whether the individual's needs can be accommodated in this context. You're not obligated to, fully remove horseback riding from your camp because such and such camper is allergic to horses. But are there ways that you can accommodate that by, maybe situating the cabin, putting her in a different cabin from where she normally would have been, or something like that. So the point of this is just to say, the answer is never just no, we cannot accommodate. The answer is open up the dialogue, start to have a conversation, and work with the parents or the employee, if it's an employee, and see if there are steps that you can do and try to get there. That's what the ADA requires of you, is that interactive process. Okay. Next, employment policies, or employee manual or staff handbook, or whatever you call it. You should have certain policies in place that run your camp. And you should keep it updated. This isn't something that you did back in 1984 and said, well, now I'm done. We've got a policy book. We're all good to go. This is something that you unfortunately have to pull off your shelf and dust off and look at. Reviewing and updating is important. It's important not just because often the facts on the ground at your camp might have changed, but also because the laws change quite frequently in these areas. And I will say that for those of you who are ACA accredited, that's one of the things that is listed as one of the standards is, have your hiring policies been reviewed by legal counsel or an HR professional within the last 3 years. So that's something that you have to be doing for ACA accreditation. I would actually suggest, even though they say 3 years, I think an annual handbook checkup is a good idea. You've got nothing else going on in the winter, take out your handbook and read it, because your workplace changes and the employment laws change. And so unfortunately the employment laws change pretty much on an annual basis. At least something will require some additional attention, I think, every year. So it's at least worth confirming that nothing needs to be changed, if nothing else. So when you're sitting down to rewrite your entire handbook, which you don't have to do, but think about the goals of the handbook. And this is one thing where this is actually a great opportunity that I think a lot of employers don't take enough advantage of, that this is your opportunity to really communicate your camp's unique goals and values, to put your story to paper. And this is why you don't want to just copy and paste a handbook you found on the internet, because it's not going to be exactly like your camp. How are we doing on time, Ron, by the way?
So we're at 11 now.
Oh
11.
boy.
Yeah.
I haven't done wage an hour yet. Okay. Do you want me to stop or keep
I'd say
going?
keep going.
Okay, I'll talk faster. You also want to use the handbook to inform new hires and current employees of key expectations and benefits. And remember, your employees are going to need to have clear and easy to understand language. Ron, I'm going to give you a copy to post that doesn't have typos in it, by the way.
Okay.
Think about your audience. They're not going to be lawyers. You want to provide guidance for your supervisors, and obviously you want to ensure compliance with all the employment laws, which change, and you want to protect yourself down the road. So these are things you might want to have your handbook have. Like I was just saying, again, this might be where you put the at-will statement. You also want to add that you can change them at any time, so that you don't have to do a full rewrite, but you can supplement. These are the big buckets of policies that I recommend, and within those there's a lot of subcategories that I'll give you, Ron, just to post for people. And it doesn't mean that you have to have every single policy. It will vary by camp to camp, but just think about it. And also, sometimes a one-size-fits-all employee manual won't work. The kitchen staff might need some different policies than your camp counselors, or you might want to have some additional ones that apply for camp counselors, vice versa. So just make sure that everybody is covered within your camp. These are the things that have changed recently that if you haven't looked at your handbook for a while, you should look. Drug and alcohol, that's because adult use marijuana is now legal. Some people still have in their policy that is not allowed. Now, let's say you have, a groundskeeper who comes in every day for work, 8 to 5 or whatever it is. He uses marijuana in his off hours. If he's never coming in impaired, you cannot fire him because he smokes marijuana at home on his own time. Same way you couldn't fire him for having a beer in his own home on his own time. So a lot of older policies have like no drugs at all, and so you have to be careful that that's, of course, with counselors that's a different story. But all of these things. Social media is another item that you might want to. Some people won't even have probably social media policy, so think about implementing one. You have to be careful there. Okay, wage an hour.
Is this the last thing?
This is the last thing.
Okay.
These are the relevant laws, and they govern minimum wage, overtime, youth employment. Biggest thing to know, starting January 1, minimum wage is going up to $12 an hour in Maine. There are exceptions that apply to you, which you guys all probably know about, but you're still going to have to comply with minimum wage for all your non-exempt staff. Other forms of compensation may be included in the minimum wage calculation. The 3M credit, which is the reasonable cost of room and board and certain other facilities. The caveat is that they have to be provided by the employer for the employee's benefit, not for the employer's benefit. So you can't force somebody to take it when they don't want to. It has to be something that they're benefiting from for it to count as compensation. And this is basically a lot of ways of saying that if somebody's working overtime and is entitled to overtime pay, you pay them time and a half for that additional, whether they are salaried or hourly, as long as they're not exempt, they get the overtime measured by the work week, and it doesn't matter how you calculate your work week, it's 7 days. Your other obligations relate to record keeping, the things that have to be in your payroll records, whether you keep them or you use an outside payroll processor. You have to keep those records for 3 years and make them available if requested. You have to have, there's the link I was saying with the posters that you might want to print out. These are the 2 posters right now. They've already updated them for January 1, so those will be the new ones, which would be confusing because the federal one is obviously still much lower than the state minimum wage. But and then you are exempt with camp counselors, which I think everyone knows, but it only applies to counselors, junior counselors, and counselors in training. Other camp staff are not exempt, so you would need to pay minimum wage to these categories of workers, unless they qualify for this other exemption we have, which they would have to be salaried and they would have to still meet the minimum salary level, which I think I have on the next page here, which I think is going up to 36,000 with the change. Let me check. And they also have to have primary duties. Yeah, the state, it's rising from 33,000 to 36,000 in 2020. So you have to pay them at least 36,000, and then they also have to be in an executive, administrative, or professional capacity, which again is a fact-specific inquiry, and it really depends on their primary duty. I tried to give a couple examples of, an executive might be a camp director, a supervisory role counts as an executive. Professional is a limited one. Some camp nurses might apply, some might not. You actually have to be a registered nurse, an RN, to qualify for the professional exemption, because it has to be a learned professional, and they only consider RNs learned professionals.
And that would include nurse practitioners.
Yeah. It's basically like whether there's sort of a state certification that you had to do that's more rigorous than the standard licensed one. And office managers might come into the administrative role. And that's it. That was, I'm sorry, wage an hour got short shifted there.
It went super
anyway, okay.
You had a lot to say there. So it was a lot to cover.
Yeah, I think we were more ambitious than
important stuff that we all know.
Important stuff, and that's a teaser.
Yeah. So if there's any questions, please feel free to write in. Or if you
make sure we
did have some questions throughout it.
Yeah,
so
yeah, maybe
that was helpful. Specific to like
those topics as we went through. Yeah, and wage an hour, before we started, Bijette and I were speaking about, if you do have questions, because wage an hour is such a complicated and thorny area, and camps do have such specific needs and circumstances, that there's somebody named Scott Cotnoir at the Maine Department of Labor. He's in the wage and hour division. They're the ones who are responsible for enforcing the wage and hour laws. So he would be the guy knocking on your door if you did violate the law. So if you have questions before you make a decision, feel free to give him a call. I've actually called him a few times with questions of my own, where it's not clear, where sometimes federal law and Maine law conflict and you need to know which one you should be following. And he's really helpful. He appreciates it. I can give you his information to post, but he's just a phone call away and is happy to answer questions. And I think you've called DOL too.
Yeah.
Great.
Yeah,
and we will post this webinar and your
my supplementals.
Yes.
I think you've got a thank you up there as well.
Yes.
Oh, good.
It was particularly helpful, the discrimination stuff.
Okay, I'm glad. Sorry to run over.
No, you're welcome. Before we end it, we'd like to gift you this, and thank you, your own Make
Thank
Something
you.
travel mug. And we really appreciate your time.
Thank you
and your
very
effort.
much. I appreciate you guys. It's nice to have people who actually care about this type of thing.
Yeah. I can see that you're like enthusiastic and excited.
I have strong feelings about discrimination.
Yes, you're the perfect person to read it.
Yes.
So you can actually like.
Yeah, well, and camps are really on the forefront of doing the right thing without,
Right.
you know, I feel like the law is actually finally catching up
Yeah.
to what you guys have been doing
Right,
all
because the
along.
culture of camp is about
The culture,
accepting
yes.
each people as a person, as a humanity.
Yeah, so it feels a little like preaching to the choir, but
Yeah.
Say goodbye.
Bye.